Welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast. Big hello to everybody in between. My name is Dan Balkaran, as you see on the bottom of the screen. I'm an employment lawyer at the law firm of Samfiru, Tumarkin LLP, which is British Columbia, Canada's leading employee side employment firm. And as you can see on the screen, I practice out of British Columbia, specifically out of sunny Vancouver. So I'm going to be answering all your questions, employment law, for the next 30 minutes or so. Please feel free to shoot them all over. And as always, just a bit of housekeeping. If you need to get a hold of us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, great. Let's start with the questions. We've got one in, but let's get a bunch more in so we can tackle them one at a time. Okay. I'm not going to say this individual's name. Maybe I'll call this person Ace. Ace says, I submitted my letter of resignation due to constructive dismissal based on the new job my employer wanted me to do. I was with the company for 14 years. Would I be entitled to any severance? Okay, so Ace, the good news is certainly if the new job is fundamentally different or the duties are fundamentally different in nature, you can quit and claim constructive dismissal, depending on how radical the change is, or it's a change to a fundamental term. I'd say jurisdictionally that matters a lot, because so in British Columbia, changes to your job duties, demotions, hollowing out of positions, triggering constructive dismissal, less likely to be successful than, say, Ontario. However, it depends on the facts. It depends on how substantial the change was. I encourage all of you. I know it's done now, but constructive dismissals are hard to get to. So what a constructive dismissal is, or I'll back up a step. When you get terminated without cause, you get severance. The amount of your severance is determined by what your employment contract says, and then if you pass that particular hurdle, your age, your length of service, and the position you held. And it can be quite lucrative. It can be as much as 24 months, depending on how long you were employed there for, and your age, and so forth. So what severance is, you get terminated, you get an amount of money based on those factors, and then it's potentially reduced by your if you haven't made sufficient efforts to look for replacement employment afterwards. So it's just a mathematical, it's not quite an equation, it's an assessment, but it's firing, how much you get, is there a reduction, total number. That's how severance is made. Constructive dismissals are different. They add an extra step, and it's a very difficult step. It's where you have to get a judge ultimately to agree that the change imposed upon you by your employer was to a term. It was to a term fundamental enough such that it is effectively terminating your employment, right? So, the example I always use: you were the CTO, now you're the janitor. Obviously, that's extreme example, but you get the idea. Was it a fundamental term? So if you go from support lead level 1 to support lead level 2, it's probably not going to do it, right? Or if your duties change a little bit, or your schedule changes from 8 to 5 to 12 to 8, like these aren't fundamental changes. So it depends on the nature of the change in question. And so because of that, they're hard to get to, and particularly in BC, they're hard to get to, constructive dismissals, because you have to get a judge to agree that there's no way you could have continued to work there. Okay. And so in a situation like Ace was in, you never want to pull the trigger on a constructive dismissal without having an employment lawyer in your jurisdiction review the facts. And it's important that it's in your jurisdiction, right? Because there are jurisdictional differences between, I keep referring to BC and Ontario, but those are the ones I know. much easier in Ontario than it would be in British Columbia. So, but yes, Ace, is it a potentially a constructive dismissal? It depends what happened. It depends on how radical the change was. I will say this. So, constructive dismissal is a tough situation for an employee. In your situation, an employer imposes a unilateral change upon you, changes your job duties. You've got about 2 months to try those job duties out, those changes, before you're deemed to have accepted them. So if you don't say anything, if you don't object and resign within 2 months, those are your new duties now. You can't. I mean, it's approximately 2 months. There's some wiggle room. There's one case in BC that says 3 months in special circumstances, but you get the idea. It's about 2 months. If you don't, those are your job duties going forward. Okay. So you've got this finite amount of time. But if you resign before trying on the changes, it reduces the efficacy of your argument, because how can you say you couldn't work in the thing that you didn't try out? So, or in the paradigm you didn't try out. So I think you're going to have a little bit of a problem there, Ace, but you should talk to an employment lawyer right away. If you need to talk to us, you can do so. Employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. Okay, next one. This is just a fan approving our firm. These are amazing lawyers. This individual approves. Big heart emoji. Thank you very much, Parker. Appreciate the love. Okay. I don't know what this person's name is, so I'm not going to refer to it. This person says, I've just been terminated without cause. My employer has given me a letter to sign that says I'm required to update my employment status in all applicable social media. Can they do this? So, I mean, yeah, it's a fairly standard thing. Why would you want to continue to represent yourself as an employee of the place that you don't work for anymore? You're not entitled to do that because you're not a representative anymore. I mean, I shouldn't say it's fairly standard. It happens often. It's not something that I've ever pushed back on. What you need to evaluate is, before you sign that letter, are the terms of the termination such that are, I'll use the word fair and reasonable, but are you, the words fair and reasonable, but did you get the right amount of severance? Probably should talk to an employment lawyer about that if you've been terminated without cause. Again, you can reach us if you want to at employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. But yes, no, I can they ask you to do that? Well, what they're doing is they're saying, I think, is they're making you an offer and they're saying, we're going to pay you this money in exchange for you agreeing to these terms. The core term of which is you're never going to be able to sue us for anything arising from your employment ever. Okay, that's the core term that they're it's called a release. They're trading money to you in exchange for a release. Now, as part of those terms, they want you to update your social media. So if you don't take the deal, they have no means to force, because you haven't agreed to it. They have no means to force you to update your social media. But why would you not want to do that eventually, right? And so I'd have to know more about why that's a concern for you. But it's for me, it's not a hill that I would ever die upon. Put it that way. I've never pushed back on that for any client. Skylar asks, employer is wanting to train me on additional duties. Is that a breach of my original contract? No. I mean, it sounds like they're giving you more responsibility, which is entirely a good thing, right? Like, so people get caught up in job descriptions all the time. Like, these are the four corners of my job duties and they can never be changed ever. And if they do, it's a violation of my rights. Well, of course, that's not the case. And you work for a business, and that business is dealing with whatever it sells in a dynamic marketplace, because humans in society are dynamic, especially with the rise of the internet and e-commerce. Everything's changing constantly all the time, and businesses go to business like crazy, and so they've got to compete hard to survive. And so in such environments, duties are going to change. Before I was a lawyer, I used to run call centers for major technology corporations. At different times, I also took on HR supervisor, manager. I think it was supervisor, HR supervisor duties, customer service supervisor duties, managers. I think at one point I held like 5 different manager titles concurrently. it's just increased responsibility as the business is trying to get stuff done and treating, and looks at you and says, well, this is someone who can handle the responsibility. Let's give you that responsibility, generally speaking. Now, if it's a thing radically different, right? Like, so for example, and it's not anything that gains you or sorry, benefits you or will benefit you in the future, I get it. But generally speaking, if they say, hey, Skylar, you're doing a good job, we need X done, these are additional duties, we're going to give these to you, it tends to help you down the road with raises and promotions. Now, if this is not one of those situations, your question is that a breach of my original contract? If your duties radically change, which usually means demotion. Like I've seen lawyers make the argument, I'm not fond of it, that an increase in duties without a commensurate increase in pay equals a constructive dismissal, which we just talked about. I don't think that can get there, and certainly not in British Columbia. But if it were a reduction in duties, then certainly there's a hollowing out of your position, and as we talked about earlier, that could be a constructive dismissal. Although a harder road in BC than Ontario, certainly. But yeah, I mean, without more information, Skylar, it sounds to me like they're giving you additional duties. Generally, not a bad thing. I wouldn't be too focused on what the four corners of your job description are, because ultimately those things don't really matter as long as they're not straying too far from what your job is. So, for example, you work as a customer service manager and they say to you, hey, Skylar, we need to go clean the toilet. That if you say no and they fire you, can they fire you by paying you zero for insubordination for just cause? No, I don't think so. But if you're a customer service manager and you deal with product line A and they say, we need you to take calls from product line B, and you refuse to do so, can they fire you for just cause? Yeah, probably. It's not materially different. So it with a lot of these things in employment law, it's, what is the actual real world impact and what is fair in the circumstances. So I'd have to know more, but I think that's probably fine. Belinda. Seen Belinda before here. Welcome back, Belinda. My aunt's employer is pressuring her to retire from her position because she's over 65. Can they force her out of her job? She was planning to work for a few years more at least. No, and well, generally speaking, no. So if she's federally regulated or provincially regulated, she's going to be protected from discrimination on the basis of age under the human rights legislation in force in her jurisdiction. So BC Human Rights Code, for example. Now, there are some exceptions to that. There's a famous legal decision in court case in British Columbia, and I don't remember it offhand the name, but lawyers who are equity partners in big firms in British Columbia, a lot of them have a forced retirement policy at 65, and that's to allow new and younger generations of blood to come up and ascend to equity partner, and so it's core to the business model of those firms. And I believe someone who was an equity partner challenged that policy on the basis that we just talked about. And they lost. So I don't know enough about that. I'll just say and how niche that exception is for that particular circumstance, where it's a lawyer making hundreds of thousands of dollars a year at a big firm and they want to keep working and can they is it discrimination to force them out? And I guess in that situation it wasn't. So I don't know enough about that, so I apologize. But I will say, generally speaking, no, they can't force your aunt out. And beyond that, I think your aunt now needs to, like, if this is real, like if they're pushing this, I think your aunt needs to talk to an employment lawyer. I think that your aunt should just to make sure that the steps she's taking going forward are properly set out for her, or properly attend to her best interests to ensure, is she just trying to get out with some money? Because if they're doing that at some point, she may be able to claim constructive dismissal, as we talked about a lot during this session so far, and then throw in some general damages due to the human rights violation. Could they reach some sort of voluntary, some sort of voluntary separation package arrangement? I think that's what they're trying to avoid. But there are different things you can do. So I would talk to an employment lawyer right away. And as always, you can reach us at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Brianna asks, can an employer place you on a suspension claiming you didn't show up if you submitted your request for a vacation day in writing and it was their mistake for not recording it properly? Well, generally speaking, your employer can't place you on suspension because they have no right to interrupt your pay unless there's a provision to do so within your employment contract. So maybe they can do that, maybe they cannot, but generally speaking, you can't claim constructive dismissal from that, although you can. And again, I know we talked about this earlier, but a constructive dismissal is where the employer has breached a fundamental term of its employment contract or your employment contract. So if it stops paying you, that's a constructive dismissal. But if a suspension is finite, probably not, right? It has to be an indefinite change. So if they stop paying you going forward, that's a constructive dismissal, or straight termination. But if they merely suspend you for 2 days or something, then that probably wouldn't be. Now, as always with everything, the answer is, what is your redress? So they placed her on suspension for a finite amount of time, I'm assuming, because you submitted a vacation request and they didn't record it. Like, this doesn't sound to me like the solution there is amicable. You need to talk to your employer about that, because if you provide proof of the fact that you submitted in writing and they didn't have it, that's their problem. And so if they're behaving that way, and I don't know how long you've been there, I don't know how important the job is to you, maybe they pay you 40% over market rates, but that doesn't sound to me like a situation that is going to be comfortable for you over time, right? And it may be that you want to look around and see if there are better options out there in terms of your employment. And I don't know if there are, but in terms of your potential employment in other locations, because if what you're saying is accurate, that's a very strange thing. Like, you submit a vacation request in writing, and I don't know what the policy is if you have to get approval or what have you. I don't know what's missing from your question, and what they're saying, but they suspended you. Like, not even like, hey, that was an error, make sure you follow X, Y, and Z policies going forward. They just straight up suspended you without pay, even though you submitted the vacation request. Like, that doesn't, like, I don't think you have really a redress at law for that, but I don't see how that relationship continues if that's the way they're behaving. So just food for thought there. That doesn't sound like a great situation. Art asks, are there any laws that say an employer would need to give a raise for cost of living? Other than minimum wage, no. Like, it's been 10 years since your pay was last increased. No, and this is a tough situation for employers. I had an employee once who he solved this problem just by bugging me every 5 minutes for a raise until he finally got one. But that can backfire. He followed the squeaky wheel gets the grease approach, and it was successful for him because we had a good relationship. But in your situation, there's no means by which you could force it other than the threat of you leaving. And so, and I don't know how realistic that is. Inflation certainly has gone up and it's eaten into everyone's profit margins, but certainly inflation hits people the most, even more than employers. And so, you can push for a raise, but maybe it's a non-starter. I worked for a business once where after the financial crisis, that particular business just froze all wage increases across the board for 2 years. In the same breath, it told us about having 50% sales revenue growth. And the reason why they did it was not because it was tough times for them, even though it was tough times for everybody else in the economy. They did it because they could, because where else was everyone going to go? And so it was a way to save money because the labor market had changed. And so here, we still have a tight labor market. So, no, there's nothing you can do, but you can vote with your feet. You can always go and work somewhere else. Now, again, if you're making 40% above market rates and you're working a mill that's the only game in town, then maybe that's just not an option. But no, your options here are ask them for a raise, but that could also be a problem. Apologies for that noise. Sorry, let me just deal with this. Sorry about that. But yeah, no, your options are ask for a raise or go work somewhere else. Look for a job and go work somewhere else. Jacob asks, does my employer have to let me take off holidays like Canada? It has to, generally speaking, if you're provincially regulated, it has to give you the day off or pay you, I believe it's time and a half under the Employment Standards Act for stat holidays if you work them. I think it's time and a half. But the answer to that question is listed in your local your local Employment Standards Act, unless you're federally regulated, in which case the answer is in the Canada Labor Code. But yes, generally it has to give you the day off, or it has to pay you at an escalated rate. I think it's time and a half for working stats. Sean asks, I'm on unpaid leave because the workplace environment is too toxic. I don't think I can return. Am I entitled to severance, or do they have to hire me back? And then if the workplace is still toxic, do I then ask for severance? Okay, so some of the things that you're saying don't match up here. So unpaid leave is not an actual status, although it was created during the pandemic as a status to sort of silo employees who didn't want to get vaccinated, but the employer didn't want to fire them. And the law has sort of moved in the direction of saying that's, I shouldn't say it's moved in the direction of that, but there's one case that, at least in BC, that has said, yeah, that's fine, even though within the arc of larger employment law, it doesn't really fit, because once an employer stops paying an employee, that's a termination, and therefore they're entitled to severance. There's no status called unpaid leave where you can avoid that law, but there was in the case of the pandemic, because it was, at least according to that one case, because it was a once in 100-year event. So, but if your environment is too toxic, it sounds like you're on a medical leave. Okay, so you're on a medical leave. You can return to the workplace. Are you entitled to severance? It depends what you mean by toxic. If you have a lot of evidence of your boss screaming at the top of his or her lungs in your face, and trying to, by email, trying to, disparaging you, speaking ill of you, yeah, that could be a constructive dismissal. But, I don't like my management, generally speaking, is not going to be a constructive dismissal entitling you to severance. It can be, but you better have a lot of evidence, and it better be objectively problematic. Okay, so classic one will be sexual harassment. That'll certainly get you there. But you'd want to talk to an employment lawyer about what you experience. The problem is that everyone subjectively experiences "quote unquote" toxicity differently, right? So, for some people, things that other people classify as mild upsets are "quote unquote" toxic. So the test is really, what does a reasonable person think? And we talked a lot about constructive dismissal today, but it's really, if a judge was put themselves in your shoes, working in your position, and they ask themselves, well, could I work in this situation? If the answer is no, then it's a constructive dismissal, right? And what we haven't talked about is the second branch of the constructive dismissal test, is where the employer, in its treatment of you, indicates that it no longer wants to be your employer. So you can get there with toxicity. It's the hardest, though. It's very, very difficult, and you need a lot of evidence. So you talk to an employment lawyer. You can do so at reach us if you want at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay. Next question. Don't have the name. I was involved in a harassment investigation. Somehow my coworkers who were not involved in the investigation got a hold of results before they were presented to me. Is this a breach of privacy? Yeah, I mean, it certainly sounds like it's a breach of privacy. The question is, what are your remedies for that breach of privacy, and do you want to continue to work there? So if you want to continue to work there, I don't know how much you can do about that other than say I'm concerned about this breach of privacy. Particularly given that it involves harassment and a harassment investigation. Generally speaking, and I don't practice in this area. I mean, breaches of privacy do touch on employment law, but what are your remedies for such breaches? What are your damages? My understanding is they tend to be very small. Some of them are regulatory. Nothing really to pursue with respect to that. And so when there isn't a good remedy, there's not a good mechanism of enforcement, right? Law is about the pain of the remedy forces better behavior, right? And there really isn't one for breaches of privacy like that. So there's not much I can tell you other than, if you had a larger claim for something else, you could use that as potential. Enhance the I guess the efficacy of your claim, but on its own, I don't think there's very much you can do. Although absolutely, I do think that's a breach of your privacy. And just sort of as an aside, more and more I'm seeing this kind of thing where there are more and more harassment investigations as society changes its perspective on what it considers harassment, what it considers bullying, and what's acceptable according to community standards. And those community standards do change, right? And they certainly are changing over time, but there's always over top of it a subjective, objective test. Do you experience it as harassment? Yes. Does a reasonable person, i.e. the judge, think this was harassment, right? And if the answer is no, then it's not harassment. Now, harassment in and of itself does not ground, like if you're the employee and you're experiencing harassment and the employer doesn't do anything about it, or it's your boss that's harassing you, harassment on its own does not, it generally speaking, does not ground any sort of compensation or trigger a termination unless it's a substantial amount that are reasonable, and you've got a lot of evidence for it, such that a reasonable person would conclude that there's no way that you could work in that environment. Then it can trigger your termination through a constructive dismissal, and then you could go after severance. But it's hard. I mean, I would say 50% of maybe not that high, but 35-40% of the people that I talk to, they all claim some form of bullying and harassment, and in almost all cases, it's not. So you've got to meet that objective standard. It's a high bar. So, but obviously everyone has to take it seriously, employers and employees, when there's an allegation of harassment. Okay, look, that's all the questions we have. We got through all of them. That's great. We're out of time. I'll just say, if you want to read, it's me on the screen. Dan Balkaran, employment lawyer at Samfiru, Tumarkin LLP, practicing out of BC. If you need to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Great questions. Great talking to you guys as always. Join us on Monday, July 24, with Chris Justice. He will be answering all your questions, employment law. I believe I will be back here in 2 weeks in this very time slot, 10:30 a.m. Pacific time. Thanks for joining us. Have a wonderful and safe weekend.